Whose fault is it anyway? When an AI agent causes physical or non physical harm, who should bear legal liability? It's a question that's received several answers, including in other episodes of the Scaling Laws Academy. Today, Anat is going to walk us through her own compelling case for using agency law to tackle this weedy inquiry. As always, we'll stick with our standard format. First, we're going to explore the fundamentals of agency law with a brief detour into the theory and utility of analogies. We'll then preview some examples of how agency law may apply to current AI systems. And finally, Anat and I will look ahead at when and if this approach may eventually warrant being displaced as AI agents become, well, more agentic. With that, Anat, thanks so much for joining the podcast.
Thank you so much for having me. I'm very excited to be here talking about AI liability.
So, as you point out in your prescient 2020 article, which just kudos to you again. I mean, being ahead of the curve, writing on this in 2020, you walk through how there's a tendency in the law to try to analogize the latest emerging technology to an existing paradigm. And I think it's really helpful for listeners who hear, well, why don't we think about this as an agency law context? Or why don't we think about this through a contract basis? Or why don't we apply, you pick the metaphor, you pick the analogy? Why there are some debates around whether we should even lean on analogies. So could you just walk us through briefly what's the danger and what's the benefit of using analogies when we see these new emerging technologies come on the scene?
Yes, that's a great question. And it's, I think, something that we face whenever we talk about law, even outside of AI and outside of tort law. We as humans want to connect to something and we see something new and we want to make sure that we can analogize it to something we already know. Because creating the law from scratch over and over again is going to be extremely hard. You can see this a lot with IP or copyright law, which also has like a liability instance with new technologies entering the field and keep on disrupting the way that we are thinking about the law and who should be liable and what is liability and if something is no longer should be under a liability situation under torts or even criminal law. But there are limitations and there are drawbacks to using analogies. They are never quite the thing. They are not the perfect fit. That's why we call them analogies. They are useful in the way that we want to think about the new thing that we are currently handling with. In 2020, even people obviously wrote about this before me, but AI liability, we have some sort of autonomous, self-thinking, autocorrection being entity. We don't really know how to call it still, even 5 years after. And we want to look for stuff that are similar enough that we can say, oh, this is what I'm thinking about when I think about AI. Let's just apply the same liability regime or a similar enough liability regime, and then the normative justification fits. But even the article itself goes over a couple of legal analogies. All of them already been discussed previously in literature, talking about property law, talking about like products that a lot of people are for in the context of AI liability, saying this is just a design defect or a manufacturer defect, and looking at it at an AI entity as a refrigerator or a toaster. And a lot of people are like, this analogy might have been useful a couple of years back, but not necessarily fits the technology advancement. When I wrote the piece, when I thought about AI liability, generative AI was not in existence, not even talking about agentic AI, which spur everything into madness. So I do think it's a good hook, it's a good anchor, and it's something that is very intuitive for us. Thinking about something that as completely new is not very helpful because we have hundreds of years of experience and building on top of that because it works. History proves that there's a reason why it exists for so long and why, for example, liability regime for product liability made sense. But keeping in mind always that it's just an analogy and we have to be flexible and not get asphyxiated on that specific connection, especially when AI 5 years ago is not the AI we see today. So if 5 years ago looking at AI as kids was completely bonkers, today I think it's still not a good fit, but we're making some progress. So always looking at this from like a suspicious perspective, but knowing that it's a very useful tool for legal scholars and students, even when you go into practice or real life and you see something you've never seen before because of technologies, because of the way human nature changes, looking for an anchor as a starting point of like, this is similar enough, let's build on that. That's a great starting position, but always knowing that it's not specifically that thing.
Yeah, and what I really appreciated about your article as well was acknowledging that with respect to emerging technologies and the institutional capacity of courts, having analogies is incredibly useful for a judge, for example, who may not be on the up and up on the latest archive article exploring the ins and outs of the latest AI models. If they can turn to an analogy, they've written hundreds of opinions or dozens of opinions on agency law. It's a lot easier both for the judge and the parties to predict how that how that litigation is going to proceed
Mm-hmm.
if we know the governing analogy. But to your credit as well, you also point out that an analogy that we may initially latch onto or may apply in several instances may not be the right analogy for every use case or every manifestation of that emerging technology. And I think that often gets lost where once you've planted your flag in I'm a
Yeah.
not and I like
Mm-hmm.
agency law for AI, there's an assumption that, oh, you only think that agency law is the way to go. Where in theory, there are many use cases that you may say, hey, this analogy just doesn't fit. So having that sort of humility and curiosity
Mm-hmm.
is really important on these questions. Is that
Exactly.
accurate, would you say?
Yes, I would also like to give an anecdote if possible. When
Yes.
first the vehicle started to appear, the first litigation in that context was frightened horses. They drove on roads and there were a lot of horses. And if we were to think, oh, not autonomous vehicles, but like vehicles, automobile that are now entering our lives are just causing horses to be frightened. So let's create regulation about that. It puts us in a box that several years later was completely irrelevant anymore because more cars came into the road, and unfortunately other types of harms other than horses running away or causing the riders to fall emerged. That's part of like not getting stuck on the thing that we think is relevant right now and being open-minded, especially with AI, especially with emerging technologies. We see this right now. I'm going a little bit into IP just because it's another
Yeah.
area that I'm thinking about. Generative AI and fair use. We're thinking about the VCR. We're thinking about file sharing. We're thinking about Google Books. All of these situations, they are good analogies. Are they similar enough to what AI is doing? Same thing with causing damages on the road, physical or property. Knowing that it's right for now, but always being able to reassess, reevaluate, especially this technology.
Right. And I think it's really fun to look back at your article because, as you noted, it's 5 years prior to all the madness that's been unleashed recently, and so you get a sense of just how quickly the technology has progressed here. And so, with that, why don't we dive a little bit deeper into the core of the paper and look at this concept of agency law? So, for those folks who are a bit removed from the bar exam or
Mm.
never had the pleasure of studying agency law, what are the fundamentals here? What are the key questions we're asking, for example, about when a agency relationship, a principal agent relationship has formed?
That's a great question. So you usually take a little bit of agency law when we talk about torts, but obviously agency law is a body of its own, and I'm going to give a general explanation in the context of torts, but corporation law and other stuff and specific agency law for people sitting on the bar is extremely important. But this gives, I think, a good entryway or a gateway to understand what it means. So when we talk about agency law in the context of liability, there is the term called vicarious liability, which we are considering as the ability to impose liability upon one person for the tortious conduct of another, with whom that person has some sort of a special relationship. So here we're talking about agency law, but more generally with vicarious liability, we can think about a parent and a child. If my child does something negligent, usually the parent will be held vicarious liable, even though they were not the one committing the actual tortious action. Another good example is if I own a car and I lend it to someone and they drive it, I might be held vicariously liable for their negligent behavior. So think twice before you lend your car to someone. So that's some country states change that law, but it's a very good common law rule to remember because you might be held liable for your decision to lend your car to someone who is not fit to be driving. Um, within that world of vicarious liability, finding some sort of a special relationship to apply liability to someone in control, we have responded superior, which literally means let the master answer. So if we have an agent who is acting within the scope of employment, which is the term that courts have interpreted agency law, and this is what we see in a lot of other places. Again, there's a doctrine made for hire in IP and copyright law, and it was also implemented as part of agency law. If the work was created within the scope of employment, the business owner or the person in charge will have the copyright protection, and it goes like rights and liabilities as well. So if we see this in the copyright area and field, that they have the copyright right and ability to control the work. In tort law, we see a situation where that person will be liable for the tortious behavior of their worker. So scope of employment is the key term that we're looking for as part of our test, as part of the way that we analyze the special relationship between them.
And just to pause there on that scope of employment question, because this brings up one of my favorite concepts I ever learned in law school and in the law generally, the notion of a frolic. What is a frolic? What does that mean in a scope of employment question? Because when do we find, for example, you're a small business owner, you have, I'm a big SNL fan, so apologies. I'm going to say you have a Chad of an employee. Chad is this character on SNL who's just incredibly aloof. And Chad gets assigned to go pick up a package in the next town over and decides that he wants to stop at Wendy's for a Frosty. And while at Wendy's, punches the cashier. I don't know why he's so mad. Maybe the Frosty wasn't as delicious as intended. Is that within the scope of the employment, or why does this matter? Why do we even have this concept of a frolic?
So that's a great question, and one of the most interesting parts of talking about agency law. So we are trying to make a differentiation between a detour, which will still vicarious liability and respondent superior be in effect, and the employer will be held liable, and a frolic, which is something that you will not be held liable, the boss, the principal, and that will only be the Chad. And that's part of it is to make you think twice before you hire someone who is like a Chad. You want to make sure that the employee is someone you can rely, monitor, make sure that he does the work properly. And if he doesn't, it goes back to you. So you're in a good position to make sure that you want to train that person better, monitor it better, pay the sanction, or get insurance. That's all of the things that you can do, and the employee cannot necessarily do it. So we want to create this distinction because imposing strict liability on the employer, no matter what, can be a little bit too extreme. I mean, they are in the best position to avoid the damages, bringing me to the cheapest cost avoider that hopefully rings, and not creating any stress in the audience, but thinking about Calabresi's bar and standard of understanding who should be held liable. The employer has the resources, the means, the tools, the ability to control the behavior of the employee in a way that puts them in the best position to be held liable if something bad goes bad. But it can be 100% in all of the time, because then we will create a conflict of interest, and there will be perversive incentives of employees such as the Chad to do whatever they want, knowing that my boss will pick up the check. And that's a situation we call moral hazards. It comes a lot in the context of insurance, knowing that I have a policy and someone will pick up the check, I can do whatever I want. We want to make sure that person has skin in the game. And in order to do that, we want to make sure that that employee knows that he cannot just go and punch someone in the face and not be held liable, because his boss will be responsible. So there's a lot of...
Just to clarify a little bit further there. So when we talk about, and just to stick with our Chad, so as an employee, as an employer, when you're trying to make sure that you don't find yourself in a situation of covering, being held liable for Chad's actions, for example, at the Wendy's, you may specify, for example, in the employer-employee agreement, hey, you are allowed to veer 2 miles off of the intended route of deliveries to pick up food once every shift. So, to what extent are you able to kind of set those parameters in advance? Or is that a way, if you're an employer, to try to reduce the odds of being held liable for Chad's craziness?
It can it can be an indicator, but if it doesn't match the facts and like actual the relationship and the nature, it will not be valid in court. I'll give you an example. If it's just an independent contractor, someone you randomly sometimes hire for them to come and do some work, and it's not an employee per se. There's no paychecks. And there's no relationship, there is no resources, or like I give you tools to do the work. It's your own vehicle, for example, in the context of chat. Then there's a good argument to be made. There's no vicarious liability, there's no respondent period. They are only independent contract, they are not my employees. But if I'll try to put it in a contract saying we do not have a relationship of workers, this person is only an independent contractor. And if in real life the factors, which I'll get to in a second, show otherwise, whatever you wrote in the contract is meaningless. So it can be a good indicator, but it's not going to be enough to circumvent the agency rule in courts. So usually when you just go to work and from work, that's a commuter rule. This is not within the scope of employment, so no liability there. There's a lot of questions we can ask ourselves. Was the trip for the benefit of the employer? Did the employer pay the travel expenses and travel time? Was that specific action made in furtherance of the employer's businesses, agenda, and so on? If it's simple detour and people got to eat while they do their work, it makes sense that is part of their work and it's within the scope of employment. If the detour is like 1,000 miles away, it makes no sense given the schedule, the work limitation, the agreements the two parties had, and then there's a good chance it will be excluded. I will also say that there are a couple of exceptions, such as intentional and criminal conduct, that usually are not under vicarious liability. So if the Chad punches someone and it's not in furtherance of their boss's work, like a bouncer. If a bouncer at the club pushes someone and it's criminal conduct or intentional conduct, it was made in for the business. So that's an exception to the exception, which we always have in law. But otherwise, it's going to be outside the scope.
And so, thinking about agency law and some of the traditional paradigms where we see agentic relationships form, or excuse me, I guess I should say principal agent relationships form, we can have an employer and an employee. You point out there's also the example of having the principal as the shareholders of a corporation, and the agent in that case would be the board of directors and the corporation. So I think folks are generally familiar with this notion of principal agent, and we can see some common examples. Why is this well suited for our use cases of AI? And to what extent, let's leave it there. I'll get to the second part first. But why do you think, of all the analogies you introduced, and that we could draw on probably dozens of more, why is this one that you think warrants particular attention?
That's a great question that I think changed over the last couple of years. But going back to this specific article, reviewing the other analogies were always something a little bit off because, again, we think about product liability. They are not the toaster or the refrigerator in our houses. There's something a little bit more developed. Thinking about them as humans. Go ahead.
To flag for folks too, if you're curious about the product liability argument, be sure to check out our episode with Professor Gabe Weil, where we discuss some of the limitations that Anat also flagged in her excellent article.
Thank you. Going into kids and humans, we have other agendas when we try to regulate their liability. We talked about vicarious liability for parent-child relationship. They will not be held liable to the full extent of the law because they are parts of our society, and we want to make sure that they develop rightly. We're not necessarily thinking about that in the context of AI. We have a situation where we have an entity, an agent, whether it's like an AI agent or a human agent, working for the benefit of someone else. This is more extreme and more powerful in the context of AI, because unlike a human, when we have different agenda and the Chad just wants to get McDonald's or Wendy's, technically the AI agent should not have that. That specific piece of technology is programmed to do a specific task or a couple of tasks, but they don't necessarily have the ability to go to go ahead and go on a frolic in a way that the same way that the Chad had in our example. So once that happens, it's even, I think, more apt in the context of AI, because the issues of conflict of interest or the duty of care and duty of loyalty that we have in the context of agency law. So my agent, as a principal, owes a duty of care and duty of loyalty to me and my interests. We can see this as with lawyers as well as with accountant or people who are doing stuff for us that involves fiduciary duties. And within the AI context, because that piece of technology does not have any other agenda or any other interest, the issues of conflict of interest and the issues of violating duty of loyalty or duty of care are not that grave in the same context in the same extent that we see with human agents. On top of that, it's kind of the other way around, which I also talk about in the article. I worry for excessive loyalty, and we've seen this a couple of times because of the alignment issue. We give the AI some sort of a task, for example, pick up all the dust in the room. And they want to achieve that to an excessive level, to the point that they will gather all the dust, put it in a bucket, and then pour it again into the room and start picking it up again, because that was the assignment. They need to make sure that they pick all the dust. And if there's no dust anymore, we will create new dust. So the excessive loyalty of me saying to my agent, do X, and I will do it so extreme that it might cause damages that me as the principal did not necessarily foresee. That's my worry in the context of agentic AI or AI agency more generally. But it's still, I think, given the special relationship that is getting even more special in these years when AI is more developed and more entrenched into our day-to-day lives, and our ability or the company's ability, which is, I think, a question we'll get to in a second, who should be held liable in non-contest. That technology, that AI entity is not a thing on its own. We can't see it as such because that will just muddy the lines even further. There's always a human that has some sort of control and has the ability to monitor, give instructions, guide that specific AI. And we see this every time we put a prompt into generative AI. It does what we ask it to do. In that sense, it's very, very, very similar, as an analogy, obviously, to the relationship we see between a principal and a human agent. And the respondent superior and vicarious liability, I think, is a good fit when we consider this that way. Again, not a perfect fit, not like it is still an analogy with its limitations, but it's a good starting point. And we can see this exactly with what I said. The analogy is good, but for example, the duty of loyalty is not sitting squarely because it's kind of different between a human agent and an AI agent. So we need to take that into consideration and maybe make adjustment. But even given this situation, I still think this is the best approach to make sure someone is held liable and not say this is just like a thing on its own. It did that decision. We saw this recently with Air Canada and a chatbot that made a promise to a consumer to not pay for a plane ticket or get a discount. And Air Canada was trying to make the claim that the chatbot is its own entity and they are not liable. And the court said, absolutely not. So if I'm using my language and my theory, Air Canada is the principal and that chatbot was the agent, and thus you should be held liable for whatever damage that ensued as a result.
I get the fundamental notion of tort law, and relatedly, as you stress in your article, we need someone to be held liable, right? We ultimately don't want victims to have no remedy, to have no recourse. And if we adopt this sort of no liability regime, then we're basically imposing the costs of innovation on other people who may not be willing or may not have wanted to bear those costs.
Exactly.
But with respect to the application of agency law, something that I think we've seen evolve since your article. So this is not a critique of it in that form, but for the application of agency law now, it seems like there are a lot more chads, and even worse, we don't know that we're using a chad. So I'm just thinking of I'll pick on my dad because I don't think he's going to listen to this. No offense to you. He's just not that interested in agency law. Sorry, Dad. But let's say my dad gets the next agentic offering from OpenAI. He has limited knowledge of the rate of hallucinations, which we know even with some of these reasoning models has remained pretty dang high. He has maybe minimal understanding of how best to prompt an agent so that it avoids taking actions. For example, he may not say, don't spend more than $2,000 on planning this trip. But then
Mhm.
let's say it goes and spends $10,000, and because it thinks that my dad is too stressed about other things, it also books another vacation because it thinks that's in his best interest.
Mm.
How do we try to draw the lines where, the scope of employment is a lot more clear than maybe what's in my best interest as just a consumer using this AI agent?
Yeah. So I think that leads us to a question I mentioned before, and now this is the time to cross that bridge: is who should be held liable? So in your example, you're thinking about your dad as the person who is prompting the agentic AI, getting the information, and maybe he specifically should be held liable because he's the principal and that agentic AI is the agent. But you also mentioned that he doesn't really have the information about the rate of hallucinations or anything that can go wrong, because most of the people I've interacted with thinking about AI consider this to be magic. It's a magic box, a black box, as we call it often. You put things in it, and it just tells you amazing thing that you didn't know could exist. So in that sense, I'm not sure that the user of these services, talking about generative AI, for example, are in the best position, the cheapest cost avoider, which we mentioned, to be held liable. At least not at the moment. So it seems to me that currently, given the imbalance between the parties who are involved in the AI chain, thinking about users on the one hand, and the people who are creating, manufacturing, training the data sets, providing it to us, um, just it seems like that side of the table, the people who have more information, more knowledge about the software, more knowledge about the technology, who are just sending it to us, mostly because we're kind of guinea pigs at the moment, they should be held liable for anything that goes wrong. If we're thinking about within the scope of employment or more broadly, the ability of the um, the ability of the principal to monitor, guide, get insurance if necessary, or pay the sanction. The people who are currently creating and distributing AI are the ones in the best position, and not necessarily your dad. There might be some contributor negligence or something that he was doing that was beneath the bar of a reasonable person. But still, I don't think we should have any severe expectations for the users to know what they're doing or be able to um, specifically guide or navigate that specific AI agent. This is not necessarily a deep pocket argument. When I talk about agentic AI agents, some people say, yes, this is strict liability. So we're thinking about deep pockets and these big companies will pay the money. This might be the situation right now, but not because they are the deep pockets entities, just because given the power imbalance, they have so much more information and needs to be incentivized from an economics perspective to make sure that they do whatever they can to prevent the types of harms that you just um, detailed that your dad will now suffer because he doesn't know specifically what he's doing. And once agentic AI will have access to your credit card and you just give a task and they will run in the background and spend a lot of money without necessarily getting your approval because stopping for your approval every step of the way is not efficient, then we are in a different problem. There is a good chance that over time, we as users will completely be more educated and understand what we're doing. And then we might be considered the best principals, the cheapest cost avoiders. I don't see this happening soon, but I do think that eventually, given how liability regimes can shift with technology being more advanced, if we'll get safety measurements and safety precautions and we know what they are and we can use them, I like to call it the safety belt for AI. Because the cars were like a death trap in the beginning. You didn't have any airbags, you didn't have any seat belts. Once you had those two, our ability to mitigate risks was exponential. It was unbelievable. And we as users had the ability and the responsibility to buckle up, and we still mention that and remind ourselves to do it. We don't know what the safety belt for AI is yet as users. I want to know, I want to hope that the manufacturers of it do have some understanding or some recollection of what that is. And they have the responsibility to make sure that it is implemented at the moment if they want to just send it out and let us use it as we wish.
Yeah, it's a fascinating thing to keep track of. So number one, just to hit on for a second, that notion of deep pockets, right? Where if we have a liability regime that doesn't really afford a victim any remedy, doesn't make them whole because the only person held liable has no money, for example, that's not a very good liability regime, right? It doesn't achieve the ends that we're hoping for.
And that's
But to
exactly the problem with like AI humans. This is a
right.
judgment proof entity. It doesn't have any money. It cannot pay for insurance. We need someone to do that. Yeah.
And here too, the who should that someone be, going into your analysis of over time, we're going to see this really interesting scenario play out where on the one hand, we're going to see users become more educated about what are the proper use cases of AI agents, what are some of the safety belts you the user can install. But on the other hand, we're going to see the labs themselves theoretically
Mm-hmm.
reduce the
Hopefully.
rate of hallucination and increase the opportunities for users to be able to put those safeguards on their agents. And so seeing how those trends develop over time is going to be really interesting about where in that AI stack, from the spectrum of the user to the developer to the engineer, who
Mm-hmm.
who ultimately is held liable is going to be an interesting one to watch. And even since, again, your article back from 2020, you flagged, hey, we're not seeing AI systems that are very autonomous. There's almost always a need for a human in the loop, and usually in a very significant and regular fashion. What I wonder for the application of agency law is what may happen when we see whole systems of AI agents coordinating together on behalf
Mm.
of various principles, right? So now it's my agent talking to your agent, talking to Alan's agent, and then they're interacting with other folks. And so now we've got this whole just chaos laden question of liability. Do you
Yeah.
think then we'll be able to disentangle all those factors to try to assign liability? Or maybe is that a point where we say, maybe this agency analogy is no longer the best fit?
That's a great question because it will just getting more complex. We still have like a handful of companies who are actually doing it. So maybe tagging those when something bad happens. Hopefully there will be more and the antitrust situation will be better. I think this ties us to questions of legal nexus. So which is obviously a part of every tort action, including the vicarious liability situation. Our ability to backtrack and see and find like an actual link between someone who can hold responsibility and liability, as in such as a human being or a corporation with an actual AI entity in the middle and harm at the end. So, thinking about finding a legal nexus between some sort of corporation or entity that can hold liability and the human and the AI, again, entity and the harm, we are looking at an issue of a legal connection, the but-for test or proximate causation. Sometimes we can't really put the finger on it in the context of the black box because there's no, hopefully, this will get better over time. But the reasonable and explainability of the decision making process is not actually there. But we, again, going to history and trying to learn from it, not necessarily an analogy, but previous cases that might be similar, we can think about market share liability. This was a very big thing in the past when legal nexus was extremely hard to prove. We had the DES case with pharmaceuticals. A bunch of pills were sold. Some of them were generic. Some people got like ill and at the end and harmed, and it was really hard to trace that specific company who manufactured it in order to hold them liable. And market share liability just tried to solve that problem of legal nexus by saying, if you cannot prove that you didn't sell, and we can prove that you in fact did sell that product in the time the damage happened, you will be liable in the share that you had in that market specifically that time. So that can also apply to try and solve the legal nexus issue. It not necessarily puts a big hole in the agency law situation. It just makes it a little bit harder to find the legal nexus because of the complexity and the multiple entities who are being involved in a given situation of harm. But I still think that it makes sense to try to track the specific human that is in the best position to control the AI entity. And because we don't know what each entity contribute to the end damage, again, we can try and look at other doctrines that can be applicable and similar to the market share liability. That is just still contested and still thinking about it, but you will see that a lot of scholars talking about AI liability, whenever they come into the question of legal nexus, is like, this is a big thing. We don't really know what to do with it yet. So we're going to put this aside and think about ways to solve the liability issue. And then we can go back to the legal nexus situation. But no one's really delved deeper enough into that because it's a big issue. You don't want to completely disregard it because it's like a milestone or like the backbone of every tort action. And we don't want to hold people liable if there was no nexus between a negligent conduct and the actual harm. So this is an underdeveloped area that is still, I think, needs to have more studies into it.
Yeah, and I think what's really exciting about that market share liability concept, uh, uh, I'm stuck with it, and I've said it enough times that I'm just going to repeat it here. I'm fairly certain it's the product of a student note that we got that whole paradigm, which is really
Probably.
exciting for any law students working on their notes right now. Know that you can shape an entire way of thinking about the law. And to your point, Anat, it's fascinating too to see this overlap with some of the antitrust concerns that I talked about with Giovanna Mastrootto in a separate Scaling Laws Academy podcast about how the antitrust nexus here is almost always on the front of our minds when we're thinking about AI governance as well. Because if we
Mm-hmm.
see just a few players being in this agentic game, well, then maybe a concept like market share liability could be more applicable in as compared to a world in which we have perfect competition. There's tons of small firms, and it becomes even harder to assign that
Exactly.
liability. But
It is all entangled. We can't think about the AI industry, just the liability. We need to think about the antitrust situation and the complexity of the structure. What you said made me think about if we think this as something that has a very strong social utility, like driving a car or vaccination, maybe those big companies should create some sort of a fund, and that fund will just compensate, and then we can completely sidestep the legal nexus issue. I'm not sure if we want to do it from a deterrence perspective, from a vindication perspective, and other normative justifications that we have in tort law. But again, the structure of the industry will also kind of navigate the way that we think about the required and relevant policy.
well, and to your point too, so much of it hinges on just how useful are these things, right? If we see, for example, as you note in your article, that they take on a similar valence to vaccines, where we just think that using AI agents is pro-social. Maybe we say that having AI agents, reduces friction, eases burdens that would otherwise exist as a result of language differences or cultural differences or what have you. Maybe we really want to encourage adoption of AI agents, then we could see that sort of safe harbor, almost no
Yeah.
liability regime exist for AI agent developers so that we can have more adoption, which is just a fascinating way of thinking about things. And I appreciate you kind of pushing us all to consider a range of different options.
I can foresee a future where AI is so important to us, just like having a car, that we will prefer to have a fund than and rather not relinquish it, because we all know the dangers of having a car, and we still, as a society, decide to use it because it has very good value to us. I can see a future where AI is the same.
Well, so speaking of bold futures, we're talking in 2025, 5 years out from your article, looking even 2 years ahead or 5 years ahead. What are some of the things you mentioned? You're studying a little bit more IP. You've penned a fantastic article on agency law. What are some of the questions or the research that's top of mind for you, or things you'll be looking out for?
So the liability regime that should apply to AI is a big thing. Right now, I am more advocating on a strict liability, vicarious liability situation. I would say that just like previously in history, there was a shift in the tort system in the US, holding strict liability for innovation in the beginning because we're kind of afraid, we're not sure. Again, we need to find a safety belt for the AI before we can switch into a negligence regime. But flying in the past was considered the most risky thing ever, and hot air balloons were considered ultra hazards. So as we move forward, technology gets better, and we know what the precautions are and how to implement them. then I can see a shift into negligence. So the stifling innovation argument, I don't completely agree with. Innovation is not necessarily stifled, it's just getting readjusted and shifting into other places. Some of the places will be to implement some sort of safety mechanisms to ensure that eventually this will just be another aspect of our being, just like driving a car. And then the shift to a negligence or an insurance regime will make more sense. So,
And just to
yeah.
pause there for a second too, I'll give you a chance because you specify this in your article as well. Obviously, that innovation stifling argument is one that I'm usually partial to, but you help refute my usual counter argument by walking through, hey, there could be a world in which we create a different regime or hold small labs to a different standard so that we have that sort of undercurrent of innovation still occurring while making sure that the biggest players aren't being allowed to just kind of go willy-nilly introducing their products without any sort of governance regime in place.
So I think that if you give big and small companies some sort of a carrot saying that it's true that right now if something bad happens, you will bear it, you will carry the consequences, you will probably have to pay a lot of money, but if you make your product safer and educate your users on how to do it or get insurance, which is a tool that I talk about in my research and something that can some sort of hedge the risks associated with AI and gives us loss prevention mechanisms. With all of that, we can eventually shift into a negligence regime that benefits everyone, but we can't get there yet unless we actually know the precautions that we can implement. And that I think is a very good incentivize for all companies to make sure that we can do better. And if we do it, we will reach a world where we can make more money. And the profit driven situation, in the sense of not paying a lot of liability situations or litigation costs, I think is a very good incentive for AI, the AI industry as a whole to do better when it comes to precautionary measures.
Yeah, and consider this again an active solicitation and open
Mm-hmm.
invite to all startups who are listening to this podcast. Reach out. We want to hear from you. We want to know what barriers you're facing, what regulatory headwinds or questions you may have. We'd love to break those down. But
I
Anat,
would
I'll
also
give
tell
you.
them that they're sorry. I would also encourage AI entrepreneurs and small companies to go and get AI policies if they are thinking about it. I'm in touch with a lot of companies working on AI insurance because insurance gets the information and they are in a good position to tell you what you can do in order to mitigate loss prevention. Then you can get lower premiums and you have someone who can back you up in case something bad happens. So another tool and that companies can think about.
I love it. Okay, you've got a friend in the insurance business. All those entrepreneurs out there, but definitely reach out to Anat. So we'll give you the final word here. Anything you want to make sure we address before we end this class of the Scaling Laws Academy?
Sure. Yes. So thank you. I do believe responding to peer is a good starting point when it comes to AI liability. I think the fallacy of AI as its own being, or even AI as a product, is not something that will be helpful when we think about liability. Thinking about negligence or thinking about even the legal nexus situation, which is everywhere. There's a big impediment, there's a big obstacle that we must face in order to make sure nobody is left uncompensated when AI causes harm. And right now, this is potentially the situation. So saying this is stifling innovation, we should let technology run free. I'm not sure this is the best approach if we want to make sure users are being protected. So even if you don't agree with the responding to peer, the analogy, there should be some sort of a liability regime in place, especially with the high pace of adoption of this technology right now. So having this conversation, making sure that people think about this when eventually it will reach the courts or legislators who are thinking about how to regulate this, they will have some sort of understanding of the situation to not just say the AI did it. Someone is some human entity or some legal entity is there and should be held liable from to make sure that they are incentivized to do better.
Well, and before I let you go, carry on your excellent research. I do just want to celebrate the fact that you are very attentive to thinking through the economic considerations, the antitrust considerations, the whole AI ecosystem considerations of your proposals, which I hope other scholars emulate, because just kind of doing a mic drop of here's my scholarship idea and this is the way it should be, and taking that normative perspective without asking, well, what if I stifle someone from being able to use a tool that would really improve their lives, or I hinder that startup from getting going? I think you're asking the right questions. And I love this debate. I love this conversation. And I'm sure we'll have you on another Scaling Laws Academy episode soon.
Yes, I would be happy to join. And if students want to reach out and ask any questions, please feel free to do it. You will have my contact.
There we go. All right. Well, thank you again, Anat, and have a great rest of your day.
Thank you. You too.